Hey folks, welcome back to the channel. Today's case brings us a defendant whose need for a cane is central to his defense. Why? He's facing charges after a brutal altercation with his uncle, stabbing him 3 times, including one in the back of the head. His defense is claiming self-defense and using his cane as the star of the show. The judge has a tough decision ahead. Let's see how it all plays out.
Good morning, William Clark Taylor.
You William Taylor?
Yes.
Case number 240-593-9801. Houston, Michigan versus William Taylor. Appearances, please.
Brian Murad, PA3665. I'm here for Mr. William Taylor. We waive the reading. Mr. Taylor stands mute. He's been advised of his rights.
Forward a not guilty plea on behalf of Mr. Taylor. Why should I not give a cash bond in this case, Mr. Murad?
Judge, he's affirmatively claiming self-defense in this manner, indicates that the complaining witness attacked him with cans and other items. He indicated that he defended himself. He didn't have a phone to call the police. Your Honor, he indicates that he actually takes care of the complaining witness. They don't reside together. I know he has a prior criminal history, but it looks like the priors that I see here, at least the assaultive ones, are over 20 years old. He indicates that he works on houses as his sole source of income. I'd even stipulate to a home confinement GPS tether in this particular matter. He actually walks with a cane. I don't think he's a general danger to the community. I think that there's a specific situation here with interesting facts that I believe will be flushed out eventually. But for all those reasons, I'd ask the court, also noting his lack of capious history or anything really recent, I'd ask the court for personal bond confinement here with the GPS tether.
This was his uncle? This was the complaining witness's uncle?
Is that what the report's indicating, Your Honor?
Yes.
I believe that's the case.
I mean, the report indicates a trail of blood in this incident. The complaining witness sustained 3 stab wounds, one to the back of the head, one to the left side of the neck, and one to the left shoulder. I understand you're saying self-defense, but one to the back of the head.
Don't say anything, sir. Don't say anything, sir. Don't say anything.
Arguably, it's not self-defense. It's the back of the complaining witness's head.
Your Honor, I think there are multiple instances where injuries can occur in the back of the head, especially when you're being rushed.
I don't doubt that. That's why I said, generally speaking.
Oh, sorry.
Generally speaking, that does not indicate self-defense. And you are correct, Mr. Rod. There are some situations where that can be self-defense, but generally speaking, if they're face-to-face, that's not considered that type of wound would not be considered self-defense. And again, generally speaking. So, given the nature of the wounds, other allegations in here in terms of how the police observed him, I find Mr. Taylor a danger to the community and will give him a $100,000 cash surety bond. GPS tether, 9 p.m. to 6 a.m. curfew. Nope. Like I said, I don't think he's a flight risk, but these allegations are very, very serious, and I believe the complaining witness is still in the hospital, not knowing what condition he's in. I mean, he could. Oh my goodness! I mean, just the description of the injuries from the complaining witness in the hospital. It looks like he's going to be in the hospital for quite a while. From the alleged with multiple stab wounds. So this is an unaffordable bond.
Yes, Your Honor.
bond determination on September 16th in front of Chief Judge McConico. Probable cause September 23rd, preliminary examination September 30th. No contact with Lamont Crocker, the complaining witness. This case is scheduled in front of Judge Marlena Taylor, presumably not related to you. All right, any questions regarding your bond and or court date, sir?
I didn't hear my bond. I couldn't hear you, sir.
Your bond was $100,000 cash surety, GPS tether, 9 p.m. to 6 a.m. curfew. September 23rd, September 30th are your court dates in front of Judge Marlena Taylor. Did you hear that?
Yeah, I have to pay $100,000 cash. Surety? What does that mean?
So, sir, you're gonna have another chance. We're gonna be able to argue your bond again at the redetermination hearing, okay? We're gonna argue your bond in front of the judge on the 16th.
On the 16th of this month, September.
So in 2 days.
Okay.
On Monday, okay?
Well, I go to jail now?
At least until the 16th, sir.
All right.
The defendant's cane might have played a role in his defense, but the crime scene painted a much bloodier picture. This courtroom drama certainly raised some tough questions. What do you think? Was this really self-defense or just a terrible family fallout? Did the judge make the right call? Let me know your thoughts in the comments, and don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. See you in the next one.